Morning, everyone. My name is Giuseppe Martinico, and I'm one of the directors of the Sant'Anna Legal Studies program, together with Giacomo Delledon and Filippo Poltanelli. And today I have the immense pleasure to chair this session with an amazing and stellar, colleague and a very good friend of mine, Dr. Nikos Skoutaris, who is associate professor at the University of East Anglia. Previously, he worked at the EUI at the University of Tilburg, where he was part of this big project called TICON, right? The Tilburg Institute of Comparative Law, where the institute where this project was based before moving to Maastricht. And he has been visiting professor in many other fantastic places. He's one of the most interesting voices in the field of EU constitutional law and comparative law. He is working on a monograph on the principle of federalism in the national constitutional tradition in Europe, to see whether it is a shared, it is a common constitutional principle or not. And today he's gonna give a seminar about this topic, but he has been writing very interesting things also in the field of EU law, stricto sensu. Understood. I want to just mention is a first book on the Cyprus issue, The Four Freedoms in a State Under Siege. I don't remember exactly the title, which was published by Arte many years ago. In that book as well, you can see what I would call the fil conducteur in his research. So the attempt to read a context characterized by divided societies in light of the federal principle. I think that this was already in that amazing book, which is a gem, and I really recommend you the reading of this important volume. Having said that, I want to thank Nikos, who is also currently visiting professor at the European University Institute. Thanks indeed, Nikos, for accepting the invitation. And without further ado, I will try to share the presentation. Let's see if I'm lucky this time. Done.
Okay. Amazing.
Thanks so much.
Thank you.
I'll join the audience.
Fantastic. Well, good morning, everyone. Thank you very much, Giuseppe and Giacomo, for the very kind invitation. So when I joined EUI many years ago to do my PhD, I was speaking with some colleagues, and we were discussing, what is a good supervisor, and there were people that they were saying, your supervisor has to be someone with many publications or has to be a very good scholar. And then there was an old guy who said, well, the most important thing about a supervisor is to be a good human being. And one of the nicest things about Giacomo and Giuseppe is that they are really nice people. I'm very happy to be their friend for many, many years, but also that they are great scholars. So before I start with today's seminar, let me speak a bit about my research, not in order to sell my research, but in order to kind of situate my current work within the broader landscape of what I have been doing so far, because as Giuseppe said, and he said it much more eloquently than I could have said it, I have been working on the same kind of issues for many, many years, right? The difference is the lens, and my work in a way is like Google Maps, in the sense that you can see the same thing from different points of view, but the main threads are always there. So my first work was precisely on well, let me go a step before. Generally speaking, my work is on EU law and the right of self-determination, right? So I have been working on how EU law accommodates different self-determination movements, secessionist movements, and things like that. So my first monograph was about the Cyprus issue, and one of the chapters was precisely about how there can be a conflict resolution of the Cyprus issue through the federal principle within the EU. That was not my idea, right? So the agreed parameters of the Cyprus issue say that if it's going to be solved, it will be solved with a new federal country. And for the last years, for the last many years, I have been working on those things, on self-determination, EU law, through the lens of Brexit, right? So I have applied a lot of my work on Brexit. I was consulting the European Left Party during the Brexit negotiations with regard to the Irish border. So in a way, the thing that you see on the left was the report that I produced for them. In a way, my work speaks to two literatures. One literature has to do with this idea of the EU as a peace plan, right? So this idea that within the EU, to a certain extent, we can hope for peaceful accommodations of conflicts, whether they are intrastate, interstate, or even constitutional conflicts. So how we can create a space where we can have those conflicts, and within this idea, federalism is very important. And the other field, the other kind of literature to which my work speaks is this idea or this literature that looks at how the EU legal order interacts with areas of constitutional law that are considered sacrosanct, that are considered beyond touch, things like territory, citizenship, things like that, the institutional structure of a state. Okay, so that's pretty much what I have been doing. Now, as every academic, I have also a skeleton in my closet, which is the picture in the middle, which is this book that I haven't finished for the last I don't know how many years. And this book that will be published at some moment, I hope, by heart, is what I'm working on, and that's why I'm also in EUI. I got some money to do some research in the historical archives of the EU. What it tries to do is it tries to see how the federal principle is applied within the European constitutional landscape. So both within the EU, but also within the national legal orders of the member states. Okay? Now, for many years, I have struggled with two things. The first thing that I have struggled is to find time to write it. But from a conceptual point of view, I have found very difficult to actually tie the whole argument together, right? So to create a coherent argument that would kind of explain what I want to say. So what I will do today is try to explain to you the main argument of the book, and hopefully to get some feedback of whether it makes sense or not. Okay. So, I forgot to mention that. So, as I said, my understanding and my work, because precisely my background is on looking at federalism in conflict-ridden societies, looking at federalism in multinational societies, looking at federalism in situations where we use federalism in order to solve a very tangible problem. My understanding of federalism is what Jackson has expressed very eloquently 20 years ago, where he says that, generally speaking, federalism is the product of political compromise and historical situated moments. So it's very much a practical solution to a problem. And this, because I have seen it in my work so far, is something that has really influenced my work also in this book. I understand federalism as a practical solution to specific problems that are posed, political problems that are posed. Okay, so what is the main argument of my book? So in a way, I have. Are you okay?
No, let me help with this slide because I don't think.
Okay.
Yeah,
Perfect.
Oh, yeah.
No, that's fine. Okay, so in a way, I have two arguments. The book has a comparative part where I see how the federal principle is applied within some of the national legal orders and at the EU level. And what I'm saying is that, okay, the EU, as a constitutional order of states, exhibits federal characteristics, and I'll come back to it, right? I mean, it's not the same federal characteristics that you see in national legal orders, but still, if we agree on a definition of federalism, and I will try to do that, we can see that the EU exhibits some federal characteristics, because definitely it's not the characteristics that we know from national legal orders, but still it exhibits some federalism. However, the federalism that the EU exhibits is uncommon in two senses. On the one hand, it's uncommon because most of the national legal orders in the EU do not exhibit federal characteristics, but more importantly, because, as I said, the content or how federalism in the EU is expressed is very different from the ones of the national legal orders, even national legal orders outside the EU, to which the EU sometimes we compare, and I will come back to it in a minute. Now, why, although it exhibits federal characteristics, we don't say that it does so, or the EU doesn't say that expressively? And here, the reason that I'm trying to provide comes from the literature on constitution making in divided societies. So the work that Lerner has done, also in history, people like Ellis, an American historian, where what they say is that in societies where there is a huge disagreement, there's a conflict about the constitutional vision of the society. So basically, we don't agree on what we want to do with a certain polity. We use some instruments of what we call incrementalist constitution making. So we use constitutional silence. We do things, but we don't say them. We leave things for the future. We use a more evolutionary approach. So the EU, in a way, to sum up my argument, exhibits federal characteristics, but it doesn't express them because precisely we haven't agreed on the finality of this project. And perhaps we will never agree on the political finality of this project, right? And that's another thing where my work is a bit different than other people's, because I don't think there is a political finality or that there is a destiny of this political project. Might work, might not work, we don't know. Okay. Okay, so what I will do now is, I spoke a bit about my research. I will provide for a very brief definition of what is federalism and how federalism in the EU has been seen in the literature, speak about the comparative part of my work about federalism in the EU, and finally, I will speak a bit about what I said before, the incrementalist approach in constitution making. Okay. I'm not going to spend too much time on that. I think that, all the people in the room and also all the people in the virtual room, you are all very much aware about the problems of how to define federalism. There are, libraries of books about what is federalism, what is not federalism. It's almost a theological discussion, and it's very difficult sometimes to filter what's federalism. Personally, one of the biggest problems that I have when I read the literature on federalism is that everybody projects his own national experiences or his own political preferences to the principle of federalism. To a certain extent, I'm also a victim of that, because my work is on conflict-ridden societies, and the definition that I give of federalism is very much influenced by that. But I think, one of the biggest problems of federalism is actually to boil down to the definition. I have provided here for a number of quotes. Generally speaking, and that's what I have also argued in a couple of pieces, and also in a piece that will be published in Perspectives on Federalism, if we try to boil down to the two main characteristics from all this literature, is this idea of shared rule with self-rule. You know, this kind of famous quote by Elazar, which has a certain biblical pedigree, but also it's something that also Watts has used. So that's one thing, that you should have a system where there are many levels of government, and those levels of government should have a shared rule, but also some territorially based rule. You know, federalism to a certain extent is linked with territory, and we see that in some more recent works. And the second thing, and that comes from Halberstam, is this idea that, okay, it's not just enough to have shared rule plus self-rule. Those different levels of government should have some kind of constitutional guaranteed autonomy, right? So they should be having a claim to some constitutionally guaranteed autonomy. So that's the working definition of federalism in the book. Is it perfect? No. Would there be people that do not like this definition? For sure. But I think that it's kind of the least common denominator, right? So it is a definition that is kind of binds together many different views of many different authors. Right. Now, so that's the definition that I'm working on. So what does the literature tell us about federalism and the EU, right? So there are people that completely reject the idea that the EU has anything to do with federalism, right? There is the book, for example, the very recent book of Eleftheriadis, right? Eleftheriadis says, you know what, forget about it. There's nothing about federalism. The EU is just an international organization. People that believe that the EU is federal are completely wrong, and let's forget about it. And generally speaking, there is this part of the literature where they put emphasis on the fact that the EU has been created through the constitutive documents of the EU are international treaties. And the way what they say is that when you have an international treaty, you cannot have federalism, right? Okay. So that's one part of the literature. There's another part of the literature, people like Mancini, where they say, okay, progressively the EU has been constitutionalized, its form is reminiscent of a federal state, okay? And people, like Mancini to a certain extent, they almost, in their work, between the lines, what they are arguing is that almost the destiny of the EU is to become a federation, or to become a fully federal system. To a certain extent, and again, now it will be a bit unfair, under this category, we can also put people that their work is comparing the EU to the US, especially to the antebellum US, saying pretty much that to a certain extent the destiny of the EU is kind of the historical trajectory also of the US. They have started at the same place, pretty much they will finish at the same place. Somewhere in between those two strands of the literature are the people that they say that the EU is sui generis. So there's nothing else like the EU in the world, right? And whether it's the democracy of Nikolaidis or the Federation of States of Larsen, who says that, okay, the EU is the only real federation in the world, we have this idea as a unique species, right? And to a certain extent, I mean, it's not that any of those people are wrong, right? It's that they have, in a way, they put their emphasis on certain aspects of the EU edifice. So that's pretty much, again, this is a very rough summary, but that's in a way the three strands of the literature with regard to the EU. Okay. So how does my work differentiate with those? I think my work differentiates in those in three ways, or at least my objection, my slight objection to all three literatures is the following. The first one, with regard to the people that believe that because the constitutive documents of the EU and international treaties, the EU is not federal, I think that this is a very rigid interpretation of how the EU is formed. To characterize a certain political system just because of the way it was born and not look at how it's structured, I think it's not the best way in order to judge the constitutional system of a system. Yes, it is true that, it's international treaties that create the EU. Yes, it's true that the member states are the masters of the treaties, but that doesn't mean that the constitutional system of the EU doesn't have federal characteristics. Okay? So that's my objection with regard to the first strand of the literature. The objection with the strand of the literature that sees the EU already as something that's completely comparable to a federal system has to do with this idea of destiny, right? As I said before, my understanding of federalism is that it's a practical solution to a given political situation. I don't think that the EU has a certain fate as such. I don't think that we should, that it follows a center Sonderberg, as Weiler says. Things might work, might not work. The question is, how does it formulate at this very moment, right? And my objection with regard to the third strand of the literature, the sui generis thesis, is that the world is full of sui generis things. And I think that one of the important things about federalism is that every federal system, and again, and I'm projecting my own experiences here. If you go to any conference about post-conflict societies, and there's somebody that says, that the system of Bosnia reminds me of the system of, there will be 1,000 people that will say, you cannot compare Bosnia with Northern Ireland, or because indeed, these kind of systems are created in a way to solve particular historical and political realities. And of course, the EU is sui generis in the sense that, yes, supranational organization, of course, is very different than federalism that we know in other places, but this doesn't mean that we cannot compare it with what exists now in the world, right? So the sui generis thesis, yes, it's important because it makes us understand the specificities of the EU construct, but at the same time, and now I'm being a bit unfair, is slightly, not that I wouldn't say unscientific, but it doesn't make justice to the intellectual efforts of those people, because by just saying that it's sui generis, in a way you become descriptive. You say, okay, those are the characteristics of a system, it's sui generis, you cannot compare it, then that's that. So those are my three objections. And you might say, okay, those objections are fine, and you could be right. And what do you suggest, you smart ass? So clearly, I'm not in a position to suggest anything that is smarter than those people, because they are way smarter than me. But my approach is different. So what have I done? So what I have tried to do is two things. The first thing, as I said, is to compare how the federal principle is applied within the member states of the European Union, to the member states of the European Union where there is such a thing as federalism. Why? Because I think that it is important to see how the masters of the treaties understand this principle in their own legal system, and how they try to kind of apply it in the supranational level. I think there is a certain virtue in seeing what the people that actually created those treaties, to a certain extent, signed those treaties, what are their experiences when it comes to the federal principle nationally? Because I think that this has an effect when they try to use it at the supranational level. So that's the one thing that I do. And the second, and through this comparative approach, what I try to show is that there is very minimal commonality when it comes to the practical application. So it's very different how the federal principle is applied at the national level how it's applied at the supranational level. And the second thing that I'm trying to do, and that will come in the second part, I'm trying to explain why is the case, as I said, through the literature on incrementalism. Okay, so what I have done so far is I have tried to define what's the federal principle. I have tried to explain the different literatures on federalism in the EU. Why do I believe now that the EU constitutional order of states exhibits federal characteristics? Because if we go back to the definition, shared rule plus territorial-based rule and constitutional guarantees, we see that all those boxes can be ticked, right? So when it comes to shared rule, again, I'm not going to go into detail. You are all way more qualified than I am. But when it comes to shared rule, you see the different levels of government having shared rule over the same land and the same people. We see that through the different institutions. We also see that through the competencies of the EU and the national legal level. We have different levels of government that they have a claim, they have a say over ruling the same land and the same people. At the same time, we have territorial-based rule. We have, national governments, we have regional governments. We have the principle of conferral, we have residual powers. So there is a clear shared rule and self-rule, and we have constitutional guarantees of autonomy. What is interesting, I think, in the EU system is that those constitutional guarantees of autonomy are not always provided by the founding treaties, right? So, for instance, there is this famous piece of Leonard's from 30 years ago where he says that, you know what, the residual powers of the member states have no reserve status, there's no nucleus of sovereignty. If the member states want to, create a new treaty where they take out all the residual powers, they can do that, and this is true, but this is a very EU-centric point of view. From a national constitutional law point of view, the national constitutional courts, there's jurisprudence there about that, they put limits, the control limit theory and all this kind of stuff, on the expanse of the EU. So, although constitutional guarantees of autonomy sometimes are not coming from the EU treaties themselves, they might come from the national constitutional orders. So again, we have this idea of the constitutional guarantees of autonomy, again, the principle of subsidiarity, proportionality, and so on and so forth. Now, yes, if we agree on this definition, or at least if we don't have a fight on this definition and we can live with this definition, we can see that the boxes are ticked. So there is shared rule, there is territorial-based self-rule, there is constitutional guarantees of autonomy. However, all those things are applied in a very different way from what we are used to, right? Shared rule within the EU is completely different than shared rule within national legal orders that exhibit federalism, right? The systems of collegiate representation of the sub-state level are very, very different to the EU, to the Council of the EU, to the European Council, and so on and so forth. The governments are very, very different. There is no state that has an executive that looks like the Commission. So everything is there, but different. Even the competencies, if we think about it, normally, if you think about national legal orders, federal national legal orders, and the kind of competencies that they keep for the federal level, what are we thinking? What are the the competencies that are always at the federal level: defense, external relations. That's not the case in the EU, right? So everything is there, but everything is different, is actually applied in a different way. Now, is that particularly surprising? Of course not, because precisely because the nature of the EU is very different than that of the member states, and because federalism, as I said, in my understanding, and Mickey Jackson's understanding, is a practical solution to a certain set of political conditions, clearly the way that they would have applied at the EU level would be very different from what we expect in the member states. So how can we explain the fact that federalism exists as a principle of organization, at least at the EU level, but it's an uncommon principle? So there are two explanations to which my work points. The first is what I said before, this idea of the site-specific character of federal arrangements. There are no two federal arrangements that are identical. Each one responds to certain political needs, historical needs, and so on and so forth. The EU has been created to deal with certain political needs as a supranational organization, so it's only normal that it would have the federal principle would be applied in a different way, as all constitutional principles. I mean, think about democracy. The way that democracy is actually applied at the EU level is very different from what we are used to at the national level. But for me, the second part is more interesting, which has to do with this idea of incrementalist constitution making. So I think one of the reasons why we have organized the EU with federal terms, but we have never actually accepted, at least in the treaties, we have never actually written down, we have never actually expressed that we have organized the EU in federal terms. Remember what happened, for example, with the constitution of the EU, right? In one of the drafts, there was this there was this provision that was saying that the division of competencies is done according to the federal principle, and they had to take it out. And we have, and that's what I'm trying to do now in the historical archives, we have other cases where there were similar suggestions to actually put it in the treaties that the federal principle is applied within the EU. I think one of the reasons why we haven't actually expressed it is precisely because the federalism is very much connected with this idea of political finality. We know that from the speech of Joschka Fischer. We know that from all the literature that compares the EU with the US, there is this idea that the EU, or at the minds of some people, the EU should end up there, right? So there is a destiny of the EU to reach this level of federation, right? To become the United States of Europe. And this is a deeply dividing issue. It's dividing the political elites. It is dividing also the people. Generally speaking, what is the destiny, the political destiny of the EU, is something that divides member states, but also the people in the member states. And also, depending on the time, we have very different views on what we want to do about the EU. We don't have a shared constitutional vision. So if we go to the literature on constitution making in this kind of societies, and as I said, I'm mainly referring now to Lerner, but also to the work that Ellis did with regard to the Philadelphia Convention, we see a certain pattern. We see that when you have a society that tries to create a constitution, but this society doesn't have a common constitutional vision, the drafters use certain techniques in order to avoid the conflict, to pass the constitution without breaking up the process. One of those techniques is constitutional silence. Again, remember what happened between the draft constitution and the Lisbon Treaty. They took out all the things that were considered to be divided. The flag, the anthem, even before that, the reference to federalism, and so on and so forth. So one thing that they do is we keep it hush-hush. We do things, but we don't call them. The second thing is we follow an evolutionary approach, little by little. We don't resolve everything at once. And that's very much part of the EU ethos. Think about the Summa Declaration, see how all the treaties were created. This idea that we are doing things in an evolutionary way, not in a revolutionary way. We create a text, we create a constitutional text that somehow represents the disagreements. So, within the constitutional text, there might be conflicting provisions. The ever closer union, but at the same time, other provisions that would kind of put a certain break to this idea. And we transfer the important decisions to the political sphere. So we don't solve everything in the text of the Constitution. We try to pass the responsibility to the political elites. So what I'm trying to do now, so what I try to do with this book is to provide for an alternative reading of this idea of federalism within the EU. I think that federalism is a principle that is applied within the EU legal order. It's applied in a different way, and it is part, the way that we have dealt with it, it is part of this idea of the incrementalist approach. We don't agree on the political finality of the project. That's why we use those tools in order to kind of circumvent the cleavages and the frictions that this principle creates to the people around the EU and the political elites. That's it.
That's what the record
Sure.
formal debate. Thank you so much, Nikos, for this brilliant presentation. Can I stop the recording this way? Here we go.